Mr. Upshaw.
Thank you, Your Honor. Your Honor, good afternoon. Randall Upshaw on behalf of Darius Franklin. Your Honor, on behalf of our motion, we'd just like to state that...
Can you just pick up the microphone a little bit, please?
Maybe
You might pick up the podium a little bit.
I don't know if it goes up any
Oh, it's up
higher.
all the way?
Some
Okay.
people exceed normal limits.
You're too tall is what we're saying.
Oh,
There
look at
you
that.
go. We got some access. There you go.
Okay, thank you.
Thank you.
Your Honors, this is a case in which we all are aware of the Franks hearing and the requirements of the Franks hearing, but shortly after the Franks hearing came the Poindexter hearing, which I think is very important. I'm not going to belabor, but the key parts of the Poindexter is that when the Franks requirements are met to the trial court's satisfaction, then those statements challenged are to be set aside and the remaining facts are insufficient. That's the case what we have here. The second point that's very important about the Poindexter case is that it goes on to say there's virtually impossible improving the non-existence of an informant. And that's why this court has given the trial courts wide discretion in making this ruling to their satisfaction that the requirements of the Franks hearing have been met. Now, taking those facts, what we have here is, in this date in question, two motions were filed at the same time. A motion to quash the search warrant because it was insufficient evidence, and a search warrant to support the search warrant. And the second part was, in the alternative, if the judge fails to suppress and quash the search warrant, then we will have an evidentiary hearing to show that the affiant told the untruth. The whole issue was on one point. It was not a complicated case where we were trying to find out if there was a confidential informant or trying to find fishing to find some information. It was always one issue. The affiant stated that 5 individuals ran through my client's front door in a 30-minute period showing heavy traffic volume. That was it. So we goes to court on the motion to quash, and it was undisputed by the trial judge that when you read the search warrant, there was no information about the confidential informant. The confidential informant gave none of the basic criteria or the information that most confidential affiant says. It was he never met the proposed seller, he never went to the house, he never seen drugs, he never seen money, he couldn't describe the house, he couldn't describe the seller, he couldn't describe the interior of the house, he couldn't describe the packaging, and he never, the confidential informant, when you look at the search warrant affidavit, it never gave you any information that the confidential informant existed. He wasn't registered, so that's one question that the judge had at him prior to any hearing. The second part, when you look at the search warrant, there was no information that could be corroborated, like if these 5 people went there in that short period of time with their license plates or any of the basic standards, things that a trial judge is used to seeing. So the judge heard and then he hears the statement of the defendant that basically, listen, I live alone, there's no 5 people running through my door, I have a problem with my door, that front door security gate hasn't been used in 6 months. That's undisputed. And I understand that the prosecutor is starting to talk about the affidavit of Darius Franklin and whether they read it. It's undisputed even when you look at the prosecutor's brief that 20 minutes prior to any of the motions taking place, it came up that the prosecutor said a copy of the affidavit wasn't attached. So right there in the courtroom, if you read the prosecutor's brief, 10 minutes before the hearing began, an affidavit was faxed directly to the courtroom where myself, the prosecutor, and the judge was. 10 minutes later, the motion to quash the subpoena of the search warrant came about. There's one issue. After hearing the motion to quash, which stated there were 6 lines in the affidavit, the judge stated that all 4 or 5 of these lines are BS. There's nothing in there to show that this confidential informant existed and all the things that I previously stated. So the judge stated on the record, I'm going to give you an opportunity. If this CI made 10 buys and was credible, and I want you to come back and bring me within 2 weeks your activity log that shows that a surveillance took place, or your field notes that says your surveillance took place, or any of the affidavits that show that this CI worked with you. And the defense counsel will not even have an opportunity, because you can submit them to me under seal. And I would just review them because your affiant's credibility is at issue with me. I think it's all a bunch of BS. So you can either proceed now or wait 2 weeks and provide me with this information, because it's all about your affiant's credibility, i.e. the police officers, because nothing is there to support that there was a CI or that anyone went through this front door. The prosecutor objected. 2 weeks later, they still had not provided any information as to that the judge required, ordered under seal. So now we're getting started with the evidentiary hearing. And what does the judge have prior to granting this evidentiary hearing? Well, the court rule says, the law says you can have sworn statements or otherwise credible and reliable statements, and it's to be to the trial court's satisfaction as to whether the requirements were made.
Wait,
well,
do you think that
I'm sorry?
you have to make that kind of showing in order for the judge to be able to order the Franks hearing in the first place?
Well, we have, because what happened is
No, but I'm asking whether it's legally required.
we have to make a showing. We have to challenge what part of the affidavit was wrong and untruthful, which we did explicitly. And we have to show that if that information is not true, it would be deleted from the affidavit. And if it's deleted, there's nothing left to support the search warrant. And the judge stated that clearly. He said, all this other stuff is a bunch of BS.
Right, that's what you have to show in order to win.
Is that a legal term of art?
I wasn't going to object to it.
So I think we're here because the Court of Appeals ruled that the judge had no authority to even order the Franks hearing because you hadn't made a sufficient showing in order to compel a Franks hearing. And I think what we're interested in is the question, so the prosecution's argument is that no hearing should have taken place, and therefore, since the hearing shouldn't have taken place, no relief should have been granted at that hearing. And I guess what we're trying to figure out is whether a hearing should have taken place in the first place, and whether you think that you needed to make some sort of showing in order for the hearing to take place, or whether the judge could have granted it in his discretion.
Does the judge have discretion to grant a hearing if he has questions about the affidavit? Can he kick the tires of the affidavit a little bit if he thinks there's...
If based upon the Poindexter case, if the judge sees, it doesn't have to be an affidavit, but if he believes based upon the evidence he has that there's a questionable belief that the information is false, then he has the right to order an evidentiary hearing to see if it is in fact false. Excuse me?
He doesn't have to order it, but he has the discretion to order it? Is that your...
Matter of fact, it says, and I quote, what it states, and I repeat, when Frank's requirements are met to the trial court's satisfaction and the statements challenged by the defendant are set aside, the remaining conduct is insufficient to support a finding of probable cause. The defendant is entitled to an evidentiary hearing. So he's entitled.
These are different questions. Whether you're entitled to it or whether the judge has discretion to order it are different.
Well, the judge has discretion.
That's all we're asking.
That's all right. Because there seems to be a conflation of two possible things. One, the judge's curiosity is piqued about the veracity of the affidavit that gave rise to the warrant, and chooses, because of that curiosity, to pursue a hearing on that. And then on the other side, there are all the formalities associated with what is called this Franks hearing. Do you think those are different or the same?
I think both were met.
Well, do you think they're the same?
Could you rephrase? Could you ask me the question again, please?
There are the formalities required for Franks.
Yes, sir.
And I'm positing that there is an alternative universe when the judge becomes concerned about the veracity of the affidavit supporting the warrant and chooses to have a hearing on that. Does Frank supplant the alternative?
No.
Okay. So that's what we're struggling with. It seemed to me that the prosecutor and the Court of Appeals conflated those two things. They said that independent of Franks, the trial judge has no authority to have a hearing of the kind that Judge Murrow conducted here.
I understand.
Do you agree that that's an accurate construction of the Court of Appeals
Yes.
opinion? All right. What do you think about that?
It's absolutely wrong. What happened is that it's very important for a trial judge to use his discretion and his experience. Now, he can't just make something up, but he looks at any type of document that he thinks is reliable, the search warrants, the affidavits, and whatever. If he looks at documents and he believes there's a sufficient challenge, it doesn't matter whether it's true or not, but he has shown or he has seen and heard to his satisfaction that it's enough to challenge that one particular theory of whether they went through the front door. And as long as that challenge has been made to the satisfaction, then he has the discretion and I believe the duty to enter into give a hearing. Otherwise, we would always be unprotected. The key part about the Poindexter is it's saying it's almost impossible to show that a CI exists. So when you get evidence like this that shows everything that the affiant is saying is either unsupported, cannot be is being contradicted, you have an affidavit and you have an individual stating under oath that it did not occur, then that individual deserves a right to be heard.
You want to reserve some time?
I reserve all what's left.
Were you going to say that?
Of course it is.
Good afternoon. Anna Quiros on behalf of the people of the state of Michigan. We are the appellees in this matter. I want to start off by saying that before Franks, a review of a search warrant beyond its four corners was not allowed. Franks created a carefully crafted prerequisites that limit the trial court's discretion to grant hearings challenging the integrity of a search warrant only to cases where a defendant can first establish a substantial preliminary proffer of material falsity. The court held that these procedures are necessary to protect the importance and the solemnity of the warrant issuing process. Judge Morrow's practice of granting veracity hearings based on unsubstantiated allegations exactly represents the type of misuse of these hearings that Franks sought to prevent. In this case, Judge Morrow did hold a hearing, and he granted the hearing suppressing the evidence, not because the defense had provided witnesses that proved a material falsity as required by Franks, but because the execution of the search warrant that happened 5 hours after the surveillance turned up only 2 large bags of marijuana and no material of packaging. According to Judge Morrow's logic, nearly a pound of marijuana was not enough to support the affiant statements of suspected drug sales earlier in the day at that house. This is a clear abuse of discretion. This court has the authority under 7.316 to enter any judgment or order as the case may require. Therefore, we ask this court to affirm the Court of Appeals ruling and to go further and hold that Judge Morrow was clearly erred in suppressing the evidence.
Counsel, can you tell me, from where does the United States Supreme Court derive the authority to preempt the state from establishing its own standards for assessing the constitutional validity of an affidavit? Where is that authority derived from? What constitutional provision?
The Franks says that the search warrants are the bulwark of protection of the Fourth Amendment. This is a Supreme Court decision that has been followed.
Fourth Amendment protections are being diminished by state standards that more aggressively allow the review of affidavits?
I'm sorry, I didn't hear your question.
So somehow Fourth Amendment protections of defendants are being eroded or diluted by state standards that allow more aggressive review of affidavits.
There is a the warrant clause in the Constitution is there to protect the defendants from unreasonable search and seizures. The policy that was referred to in Franks was meant to protect the public policy to have police go and obtain search warrants and allow hearings where a substantial preliminary showing is shown. Therefore, the defendants are protected and they can have these hearings.
Are you sure that the Franks decision is, even at the federal level, is, as you say, it is the only means by which a trial court can test the veracity of an affidavit supporting a search warrant?
Well, to answer the question,
there's no discretion other than as permitted by Franks?
The Franks, even before Franks, you could go and you could review the four corners of the search warrant for probable cause, and that's what was done here, and the judge found probable cause. In the paragraph 5, which is the affiant's right, his personal observations. Beyond that, you can request, and that's what Frank says, you can request hearings to challenge the veracity that can go beyond the four corners, but you have to do something than just do mere allegations. Curiosity, Your Honor, curiosity of a judge is not sufficient.
Let me ask this question. So what if the state legislature passed a law that said trial courts shall allow hearings to contest the veracity of all allegations in every search warrant? Is your view that that law would be unconstitutional?
No, I'm not saying that. There is no mechanism at this point that allows that. What that does, though, is diminish any reason, any public policy to have search warrants. So
yeah, but the state of Michigan could decide the state of Michigan, well, I suppose the state of Michigan could just say we're never going to search anything, so therefore we're never going to have search warrants, and that could be our public policy. I think that would be a bad public policy, but I'm a judge. I don't do public policy. So I guess I don't know if the state legislature could pass a law saying every single search warrant shall be subject to a hearing to test whether or not the allegations are truthful. What is it that forbids this judge from doing it as a matter of his discretion? Is it that no such law has been passed?
Well, it's clear that he can always go, there's always a challenge. I'm not saying there's no challenge that's available to the defendant. As a matter of fact, the defendant's own affidavit could have, if it was sufficient, provide enough information to warrant a hearing.
Of course, he could have met the Frank standard. Let's assume he didn't meet the Frank standard. But I'm saying, what if the legislature had said, I don't care about whether a defendant meets a Frank standard. I want a hearing in every single case to make sure that our warrants are valid. Is that unconstitutional? Would the state legislature have the power to pass that?
I believe that, I don't think that would be unconstitutional.
So they could do that. So they haven't.
Right.
So I guess the question is whether trial judges, as a general background norm, have the ability to order hearings in a wide variety of cases when they feel like additional probing might be required.
Not under the state of the law right now.
What is the state of the law that prohibits it?
Franks, this state in this court must honor Franks.
So play along for a minute. So assume the affidavit in a case filed right here in Lansing Circuit Court says, the police officer's affidavit says, my CI repeatedly bought marijuana from Chief Justice Markman on January 12th at 3 o'clock in the afternoon in the Learning Center. He was hiding behind the big portrait of the 3 women jurists and selling marijuana. He had his muscle. It was Justice Young. He was at the front of the Learning Center. He was the lookout.
No, I was the lookout.
Okay, yeah.
And he was armed with his cane.
Yeah, exactly.
And that was your affidavit. You, the prosecutor, went to court with that affidavit, and the circuit court judge in Lansing sitting over there said, you know, I don't think so, because I was watching oral arguments that day, and I saw Chief Justice Markman at 3 o'clock on January 12th on the bench.
That would be, yes, that.
Could the judge order a hearing to say, I want to kick the tires of this affidavit a little bit? Doesn't strike me as very
Because, Your Honor, that would get to the truthfulness and allege a purposeful, an intentional misstatement of the truth by the affiant. And what you do is you're presenting evidence to go beyond the four corners.
What's the difference between the judge recognizing these allegations don't look like they scour to me in this case, and Judge Murrow's circumstance?
Well, and I do welcome this Court to actually resolve this issue on the amount of evidence that is necessary to, or that is required to hold a Franks hearing, because this Court hasn't spoken to that specific part.
The premise of your argument is that Franks is somehow binding on a separate sovereign, which is the state of Michigan, which is a curious proposition to begin with.
Well, this Court ruled in Franks in the Reed case, which is, I think, is a 1987 case, where the part of Franks that was at stake there was the judge's findings after the evidentiary hearing. So all of the lower courts have followed Franks. This Court itself has followed Franks.
Following Franks is not the same thing as saying that Franks is the only method by which a judge may test the affidavit supporting a warrant, is it?
I believe it is.
Okay.
Yes, my answer is yes, it is.
Okay, if it isn't, if the Court disagrees with you,
all right,
then isn't it the case that the prosecutor did not challenge the trial judge's exercise of discretion, only the fact that a hearing, Franks or otherwise, was held?
You mean that we didn't file an interlocutory appeal? Is that what you're asking me?
Well, I'm trying to figure out.
We did object to it. We said there was no offer of proof.
I'm trying to figure out where we are on appeal.
Okay.
If the Court disagrees with you that the trial judge does have the authority to conduct the kind of hearing that was held,
okay,
I'm trying to figure out, is the exercise of the trial judge's discretion at issue any longer or not? Has that been waived by the prosecutor?
The prosecutor never waived the judge's decision in holding the hearing.
You do if you don't challenge it.
Well, we objected to it. We did file it. We did brief it, and we did appeal to that to the Court of Appeals, both with regards to the procedural requirements of Franks and his ultimate decision to suppress it.
Did the Court of Appeals rule on his exercise of discretion?
No. It was briefed. It was argued. They passed on that.
If we rule adversely to you on the first issue, that the trial judge may in fact do what he did, must we remand then to the Court of Appeals to determine whether the exercise of discretion in that hearing was proper?
If you don't, I think you have the authority to make that ruling yourself, but you can certainly remand it to the Court of Appeals to make that decision.
What I'm asking, is the issue of the exercise of discretion still open?
Are you talking about granting the hearing or? No.
No, the actual exercise of his discretion once the hearing was held.
The ultimate
The Court
decision.
of Appeals.
You mean the suppression?
Yeah.
Yes.
Suppression.
The suppression is still an open issue. That was briefed in the Court of Appeals, and if this Court's, I think the best resolution is to return it to the Court of Appeals. If this Court doesn't want to decide it, for them to decide that issue that was argued before them.
Did you waive that by not making it part of this appeal here?
I won in the Court of Appeals. In my application, I won in the Court of Appeals. At that point, there was nothing really for me to appeal.
You had prevailed. Okay.
Wait, I have a question. Are you sure you preserved this in the Court of Appeals? I mean, in your brief, your question presented talks about when the judge may order a Franks hearing, and you say basically the judge shouldn't have ordered the Franks hearing. I guess your last line says it was error for the judge to order the hearing and to suppress the evidence?
Yes, I argued both. I presented both in my brief, And I did,
Is that in the Court of Appeals?
I'm sorry, in my brief in the Court of Appeals?
Yeah, where in your Court of Appeals brief did you preserve this?
I reviewed the testimony that was.
Is it an issue presented for decision in the Court of Appeals?
It was. I did
Where?
request that the suppression be set aside as well.
Yeah,
On
but
what
you-
basis?
That was because you thought the hearing should never have
No,
been
no,
ordered.
no, because the evidence, I did talk about the evidence that was presented. The evidence that was presented at the Franks hearing from Ms. Jones and the defendant, Mr. Franklin, was actually worse than the information they put in there.
We're asking a very technical question.
Right.
Did you preserve it?
I did.
And how, yeah. And
I did by arguing that the suppression was clear error, was also erroneous. The suppression itself. I made that argument in my brief.
Let me ask you another technical question.
I'm sorry?
Let me ask you another question. It strikes me that the determination of how to assess the trial court's decision in such a hearing is not quite as clear as I would have thought. Is there any work to be done by this court to clarify that a judge's determination on this kind of inquiry about the propriety of the supporting affidavit is a discretionary review and subject to a abuse of discretion? The
judge's decision on whether to hold the hearing is the review of that would be abuse of discretion. And
once he's held the decision and made the decision?
His ultimate findings would be reviewed for clear error, as it was in Reed.
Are you familiar with any class of motions as to which the courts would not have the discretion to at least hold a hearing? And again, I distinguish, as my colleagues do, between the decision to conduct the hearing and the ultimate resolution or the ultimate decision of that hearing. But is there any class of motions as to which the court would not have that discretion?
No, because the Delaware case, in Franklin, Delaware had a ban on any hearings.
I'm not asking about a Franks hearing. I'm asking about a court's response to any motion dealing with almost anything. Isn't there discretion on the part of the court to say, I'd like to look into that a little bit more?
Justice, of course they have discretion, and I'm not saying they don't have discretion in this case. I'm not saying that Judge
you were
Morrow.
saying they didn't have
right.
discretion.
They have discretion to review cases to determine whether there's going to be a hearing. And Judge Morrow had that discretion, but abused that discretion. Also, he clearly erred in finding that there was enough evidence to suppress the evidence at the end.
I guess I like to keep it general. I mean, I kind of like to look at things in a common sense approach sometimes. And I guess where I'm trying to have the problem is that here you have a judge that basically wanted to grant that granted due process or more due process. Where I think that the court is having trouble is how is it a constitutional violation? How is it abuse of discretion for a judge to decide that he wants to use his discretion? Because that's the whole idea of a trial court judge, is this court has always given deference to trial court judges to make these determinations, to make these evaluations, to hold these types of hearings. And how is it that is a violation to allow for discretion for the trial court judge?
Justice, that is not an unfettered discretion. I think that it's reasonable, and the state of the law in Michigan does give the judges discretion, but they first there has to be something more than a mere conclusory allegation to warrant going beyond the four corners. Now, this court can rule, it has discretion, you can rule that we're not following Franks, but the problem with that is that every time, as is done in Judge Morrow's courtroom, every time you have a mere unsubstantiated allegation.
Let me understand. Under your premise, where do you want this court to draw the line, specifically?
that there has to be more than a mere allegation.
What does that mean?
What it means is, and Franks is very specific
No, I
about
understand
it.
what Frank says. I'm
Right,
asking
but I
you.
want the court to adopt Franks or to follow Franks. A substantial, when they use the word substantial, when the United States Supreme Court uses the word substantial preliminary offering, it means that there has to be, it has to be of some considerable amount or value.
What does that mean?
The mere conclusory allegations, especially self-serving allegations that are not objective in any way, are not enough to go beyond the four corners of the.
So I understand from what you're arguing what is not enough. What is enough?
What is enough?
Yeah, I mean, you gave the example
Sure.
that, we gave, you gave the example where we were talking about the selling of drugs in the Learning Center, where there's perhaps video that shows that we're all up here at 3 o'clock.
Well,
I think
That was Justice McCormick.
yeah.
Well, let me-
but I
let
think
me
Justice
just- let me
Young
go
was
back to
trying
this.
to ask, but I think Justice Young was trying to ask is, when you don't have something that's that blatant, that's
Right.
that obvious, tell me when.
Well, let me go back to the facts of this case. If the defense had produced the affidavits or an offer of proof, which they didn't at the time that Judge Mora granted the hearing, of Ms. Jones's statements in her affidavit, if they had produced that, and I do argue that in my brief, if they produced that, we wouldn't have a quarrel, that there could be a hearing. It turns out after the fact that none of these affidavits were produced until the application in this court, and I think that's very clear too.
But there still has to be some discretion here, doesn't
Right, but
there?
then-
There's
then
no
we have-
certain, there's no, I mean, would you concede that it's going to be very difficult to have an absolute line that says you must do this, or if you don't do this? There still has to be a little bit of a gray area that the trial court judges have to operate within, isn't there?
And I think that abuse of discretion is a high standard for us to meet, which we did in the Court of Appeals. And I believe the Court of Appeals was correct in that. They assumed that because the defendant's affidavit was floating in the trial file, that the Judge Morrow must have read it, and that's why they ruled that way. But Judge Morrow's reasoning had nothing to do with that. If you look at the transcript, Judge Morrow granted the hearing because he wanted to see whether the affiant was a blatant liar. Based on what? Based only on the fact that the defense alleged that he was lying. We have reason to believe that's the only thing that was argued. We have reason to believe that he never spoke to one of the people who he alleges went up to the door.
Okay, I think your time is up.
Okay.
Thank you very much.
Thank you very much.
And let me say for the record that Justice McCormick's illustration concerning Justice Young and myself is a hypothetical.
But I still am on the lookout.
We stand in recess. Thank you.
We'll see.